Welcome to Third Fridays, the monthly legal talk show from Lois LLC featuring attorney Christian Cison. This is the original forum in which real attorneys discuss workers' compensation issues, share their opinions, and engage in colorful conversations. This show showcases diverse perspectives of attorneys handling workers' comp cases, including case law trends, practical litigation strategies, and hot topics. Here's your host, Christian Cison.
Hi, everybody, and welcome to the July 2022 edition of the Third Fridays podcast. Summer is flying. I hope everybody's getting some sun out there and enjoying, the best of what the East Coast has to offer. Today, we have a few guests. Before I get to my first guest, I'll highlight my second and third guests later on the show for the Paralegal Minute. It will be Marquita Joseph and Nicole Yakimic talking about a very interesting case that involved a captured on video death. Not a snuff film, not anything crazy, body cam footage of someone passing. It's very, very interesting, and it did result in a more expedient resolution, to say the least, but we'll be going over that case with those two later on in the show. But my first guest today is Senior Associate Christopher Major. Anybody who's listened to this program has probably heard his voice plenty of times throughout the year. Welcome back to the show, Chris.
Thank you. Thanks for having me. I usually insist on showing up about once a year, so here we are.
Right, you hit that quota.
Yeah,
it's still July. I mean, I might have you on by the end of the year with how things are progressing very nicely for you. Specifically, we had a great win on your end in a civil case that resulted in an extreme amount of windfall savings for our client. I hope everybody tuned in to the special webinar that was released earlier this week. If not, that's C Major at loisllc.com for any information on how to access that webinar and see how great he is, because it's the kind of win that really exemplifies everything we do here at Lois Law Firm. Super excited. Cannot have a better guest this month based on the win that you provided to this firm, Chris.
And I will note, if you're tuning into the Third Fridays podcast, chances are you're a bit of a comp buff. So lest you think that this is just a regular old civil win, but for the knowledge of sections 11 and 29.6 and the concepts of workers' comp exclusivity, this win doesn't happen. So heavy overlap with workers' comp. So if you're into the New York workers' comp law, tune in for sure.
Well, we want to drive listeners to the webinar.
Yeah.
just a comp joke, obviously. Okay, let's get into why we're here today, Chris. And then I think it's specifically with respect to a still relatively current event in New York workers' compensation, and that's the onboard prior authorization request system, more commonly abbreviated or known as PAR or PAR. And we know that what we do in a workers' compensation case in New York has overreaching effects outside of just the comp case. And that's where your specialty kind of kicks in. And specifically with respect to the health insurance matching program. Now, we've actually had a podcast on what that program is, but if you could be the briefest of brief, can you tell our listeners what the program is?
Yeah, briefest of brief. A private health insurer pays for medical treatment that they thought the comp carrier should have paid for. The health insurance matching program, or HIMP as we're going to call it for brevity's sake for the rest of this podcast, is how they get reimbursed from the comp carrier. It's a procedure through the board to get paid for treatment they thought the workers' comp carrier should have paid for to begin with.
And, in our experience, right, HIMPs are ratcheting up. We've had more clients come to us and say, help us with this. How does this work? Would that be fair to say?
Yeah, and they're kind of... I've been banging the hemp drum from the mountaintops for a couple of years now because they're kind of nightmarish with the shenanigans that these health insurers can get away with in some instances. One particularly egregious thing that I'm just going to throw out there because I'm indignant about it is the process of serving a hemp and then 30 days later sending you a thing saying you haven't responded to this and it is now payable, which is just not true because you have 90 days to object. But they know most carriers are just looking at these forms and going, I don't know what this is. Let me sign off on this payment. And they're banking on that. So make no mistake, we're recommending fighting every single one of these things tooth and nail. You can just have thousands and thousands of dollars, especially in some, big surgery cases that we denied, like maybe a lumbar fusion, which required prior authorization. Nice little segue into what we're talking about today. But especially in one of those where maybe a denial is upheld, you can have a bill for $100,000 that crawls through the door, a year after a Section 32 notice of approval comes out. I mean, it really is, nightmare sounds a little bit of an exaggeration here, but they are quite pesky. Let's put it that way. There's these, posthumous demands for reimbursement coming across your desk when you thought your books were closed.
Yeah, I think it's very interesting because when you get to a point of having this this side channel of a trend that's happening with, I guess the indignancy of what's going on. I can tell that, you're really on your game with these hemp claims and requests. So if anybody wants to go back into a really detailed approach on how we deal with these types of issues, there's certainly a prior episode of the Third Fridays podcast that we can give you. But let's focus on the current event being on board and par, right? So we have now a situation where new medical treatment guidelines apply as early as 2 months ago, that this now onboard system is now putting forth the option for providers to request confirmation that treatment exists within the guidelines, that treatment in excess of the guidelines are being responded to in a timely manner, followed by orders of the chair immediately if these deadlines aren't met. Now, some of the deadlines remain the same. We're not going to get into the thick of 15 calendar days or 15 business days, 30 calendar days, IME report, not an IME report. The idea is that inputting this system in place is necessarily going to result in more treatment being authorized, because it's going to avoid or hopefully avoid the use of people like us, where we say, wait, we have a legal defense to this treatment authorization. And the board, I believe, is trying to sidestep that, take it out of litigation by making people determine medical necessity only. Now, how would that affect a future hemp claim?
Yeah, so speaking of the righteous indignation about hemps, I can hear it in your voice, Christian, that you're indignant about this end run to these orders of the chair now.
Well, now I'm more upset with myself that I used the wrong noun form of it. You're right, it is indignation. I said indignancy, and now I've lost all credibility with my own audience.
Nobody would have caught that had you not pointed it out.
Well, I'm an overanalyzer, if anything.
So we were looking at this, talking about it beforehand, and so let's get the bad news out of the way first, right? So we do have this sort of end run looking at medical necessity now, taking sort of the legal defenses out of the equation somewhat, and of course, we still have our defenses and we can still fight even under the PAR system. But let's look at the potential negative impact here, just from a hemp perspective. When is a hemp most likely to pop up? When treatment was denied during the workers' comp claim.
Right, because they're actually not going to the carrier, right? So the claimant is moving to private or some other insurer to pay for treatment that they believe that they need.
Right. And, this is where these hemps come from, is a private health insurer ends up footing the bill for, a denied lumbar fusion surgery, and they go, well, wait a minute, this is a comp case. You guys should have paid for this. So,
Can we actually just I know this is actually now escalating above what we talked about, but why isn't that private health insurer denying the treatment bill like outright if they believe it's part of the comp claim? Why do you think that happened? Why do you think they're even paying for it in the first place?
Because they have an obligation under the health insurance law to actually pay for the treatment, if they have all the documentary evidence in support of it that they need. So, they're not in the position that we are in workers' comp, where you're able to raise as a defense, there should have been a priority of payment thing here.
Isn't the documentation that they receive also sometimes inclusive of a history that this is a work-related accident?
Which is their trigger to go out and get a match from the board eventually, yeah, in theory. But, my fear here, to a certain extent, is that the more denial opportunity we have, and part of the thing Christian and I were talking about is this going to open up more potential requests for confirmation of treatment, confirmation that treatment is consistent with the guidelines. And, we hadn't seen a heck of a lot of MG1s before this, but, is there going to be this new sort of attempt at compliance by providers using this PAR system, and maybe perhaps an overuse? And, my fear is that to the extent that this opens up any additional denials or denial opportunities for us as the workers' comp carrier, my fear is that is going to result in more back-end HIMP exposure, right? The more bills we say no to, the more private health insurers probably footing the bill for those. You can bet the provider's looking to get paid from somebody. And then the more a HIMP is going to show up as soon as they get a match from the board. Ideally, they're getting a match. Again, here comes my indignation. Some of them just serve you blank HIMP forms that don't even have the WCB. Don't get me started. But so one of my fears is this potential increase in opportunities to deny equals increase in opportunities for HIMP exposure. Another one of my potential fears, and this is somewhat unfounded, is that perhaps because the way the HIMP rules and regulations are somewhat inartfully worded at the moment, to accommodate the new MTGs and to accommodate the PAR system, perhaps the molasses in an igloo New York State legislature amends the HIMP rules and regulations, and then we get a new effective date, which then gives every, health insurance carrier another year to serve HIMP reimbursement requests, because that's one of the measures of timeliness. Now, outside of those two potential issues, I am sensing some opportunity here. Would you like to hear how?
Well, I do, but if I didn't, I don't think I'd have a choice, given that that's the reason we're talking here today. So please, go forward.
So, number one, we do have this. We do have these new MTGs that took effect back in May. So, one of the objections under the HIMP rules and regulations, 6.4B11, is treatment inconsistent with the medical treatment guidelines. We now have more than just neck, mid and low back, knees, shoulders, etc. We now have MTGs. Comprising basically every type of treatment you could think of, with the exception of some of the ones that we've already discussed in our prior conversations, Christian. But we do have a whole bunch of new medical treatment guidelines where we can say this treatment was inconsistent with the MTGs. I would note that there's this interesting little quirk in the HIMP rules and regulations where they tell you can't object based upon the following things. And one of the things that they prohibit an objection based on is a failure to request prior authorization for special services costing in excess of $1,000. Now, why am I bringing this up? In the old form of C4 auths, the way this would play out is we'd have these health insurance carriers saying to us, no, you can't object based on failure to file a C4 auth. See, it says it right here in the regulations. You can't do that. Thing is, the regulations cite to a very specific portion of the workers' comp law, which references only special services costing in excess of $1,000. So we were able to make this rather, in my opinion, artful argument that, no, this doesn't prohibit objecting based on failure to file a C4 auth. This prohibits only C4 auths, in excess of $1,000, objecting on that basis that they failed to file that. C4 auths for lumbar fusion or arthroplasty or things of those, those procedures specifically requiring prior authorization under the MTGs. If you fail to request prior authorization for that, that's just plain old treatment inconsistent with the guidelines, which takes us back to the first objection I just brought up, which is an objection based on treatment inconsistent with the guidelines. So we do have these new MTGs, and we do still have these specific procedures that require prior authorization.
And that kind of goes in line with what we did discuss last year about HIMPs, which is if you can use it within the confines of the workers' compensation law, then there is an analogous argument to make in defending the HIMP claim as well. So what you're saying is it actually, because, and to make that analogy perfect, right, I'm looking at the implementation of new medical treatment guidelines for new body parts and new conditions as a benefit to employers, because now providers have to request treatment that isn't now delineated within those guidelines. The guidelines also provide a standard of predictability to us to make us realize that, hey, if you have this type of injury, then this can actually enable us to project future medical costs on a more confident basis because we know that the guidelines say that things are pre-approved. So if we can, focus on the treatments that are outside those guidelines, then I agree, that would definitely be helpful for future HIMP defenses.
100%. And I would note that, the rest of our defenses here under the HIMP rules and regulations, despite the implementation of the PAR system, just based on what we've looked at so far, all of the same defenses still apply in my estimation. And as Christian just artfully pointed out, they're largely the same defenses you would have if you received a bill on the workers' comp claim. Things such as there was a Section 32 that closed out medical treatment, or there is a Section 29 offset, one of my personal favorites for obvious reasons. The authorization for this treatment was requested and denied by the board or denied by the carrier, no review was sought, or treatment in excess of the fee schedule, an objection you have in literally every single HIMP demand you receive. If you're not objecting on at least that ground, you're doing yourself a disservice. So all of these same defenses still apply, but one of the ones that I just mentioned that is kind of interesting to me is this concept of denied treatment, right? So we have a specific HIMP objection that says you can object based on treatment for which authorization was requested and denied by the board, right? So board decision comes out saying the treatment is not authorized, or was denied by the carrier, but no review of that denial was ever sought. You can object based on that ground, this denial by the carrier with no subsequent review by the provider, or straight up denial by the board. So if we're afforded more opportunities to deny treatment, there is an opportunity here, not just in the MTG's objection to HIMPs, but there's an opportunity here to object to HIMPs based on these increased denial opportunities we have, right? Not just on the new MTG sites, but based upon these requests for confirmation that treatment comports with the guidelines. Can you, and this is something interesting we're going to have to explore, but can you call a denial of one of these requests for confirmation? You described it as the warm and fuzzy feeling these providers are looking for when they're rendering treatment. Can you call that denial a denial under the HIMP rules and regulations? And the short answer is you'd better believe we're going to do it because we're as aggressive as possible.
Well, look at it this way, right? I actually think it's even more cut and dry, right? You have, what Chris is talking about is a specific PAR, a specific prior authorization request, where the provider is asking the employer to confirm that what they want to do as far as treatment is within the guidelines. So if it's not, and we say that it isn't, and they don't appeal that ruling either to make it a variance or whatever, they're agreeing that it isn't within the guidelines. And therefore, if they render it, you now have that guidelines defense for a HIMP claim because they requested confirmation, they didn't appeal the decision, they didn't turn it into a variance request or a different level of PAR, and now we have a situation where they render the treatment anyway. So it actually makes the decision point or the argument even easier to digest because you're going in there and you're saying, well, what's the point of this PAR process anyway? They're going to request confirmation that it's within the guidelines, and when they're told they're not going to do it, they're going to treat anyway? it's one of the more common sense procedural arguments we can make as far as the landscape of what we do.
Oh, it definitely expands the, potential objection on the grounds that, this treatment is outside the guidelines. Where we used to be able to get away with that in HIMPs was in a couple of very specific scenarios. No MG2 was ever filed, right? And we can just point to the type of treatment and say, this is not within the guidelines, hence it is outside the guidelines, right? Sort of absence of equals the existence of argument. And then there's also, you filed an MG2 and we denied it, which means that you as the provider acknowledged that the treatment was inconsistent with the guidelines. We denied it, and either you never appealed that denial or the board agreed with us and upheld the denial. So those are sort of these like limited instances where we could say, hello, here we have proof that this treatment deviated pretty much per se from the guidelines. What this is creating is an additional opportunity for us, in as much as these guys might just be seeking this sort of, and these guys, I mean the providers, this sort of innocuous confirmation that, hey, just want to make sure everything I'm doing here is right. Is this treatment really consistent with the guidelines? I'm pretty sure it is, but could you just make sure it is and just tell me it's okay?
Can't you see that's the warm and fuzzy? It's like you just want that piece of paper saying that makes you all warm and fuzzy that you can bill an insurance carrier for.
Right. And I think, there is an opportunity to be had here in saying, well, we denied it, and now it's, that's pretty much evidence. You weren't sure. We said it was denied. It's not part of the guidelines. We've created an argument where one didn't exist previously. What I was getting at, in addition to that, is this argument that we can now also call that denial that we file, saying like, no, you're incorrect. This is not consistent with the guidelines. We can call that a denial of treatment. And if they don't take it to that next step, right, where you said, oh, they're just going to turn around and either request further board authorization or, they're just going to turn around and do the treatment anyway. We can turn that failure, if they don't take that next step, into another HIMP objection that authorization for the treatment was sought, it was denied, and no review was sought. And that's the beautiful thing, is we're not just having these expanded MTG objections potentially, but also these expanded objections just based on the concept of a denial of treatment for which authorization was sought and no subsequent review was sought by the provider, or the board upheld the denial.
Okay. Yeah. I mean, I think that really sums up the opportunities, right? I did lead off with some pitfalls though, right? Because of these deadline-oriented requests that result in orders of the chair. Now, let's say that happens and the treatment's maybe already rendered outside of the workers' compensation claim. Are we kaput? Are we dead on that future HIMP claim?
If the treatment was rendered outside the workers' compensation claim and an order of the chair comes down saying that the treatment should have been authorized, is that the circumstance you're describing?
Or it was authorized.
Okay. So we still always have the remainder of our defenses under the HIMP rules and regulations, which, is the timeliness argument. Did they get a match from the board within 3 years of the date of payment? Did they serve it within a year of the match date, a year of the date of payment, a year of ANCR of acceptance, a year of the effective date of the HIMP rules and regulations? Is the treatment consistent with the fee schedule? Was authorization denied and upheld by the board, or denied and no review was sought? Is it consistent with the guidelines? Is there a Section 29 offset? Is there, so the other thing that's really kind of nice is I mentioned that the HIMP rules and regulations prohibit a series of specific objections. They also give you a catch-all. So if you've ever seen the HIMP form itself, there's part one that the carrier, the health insurer fills out, and that's the, request for reimbursement. Then there's part two, which is the carrier's response, the workers' comp carrier's response. What's nice about that is it lists 1 through 11 pretty much verbatim the objections that are specifically delineated in the HIMP rules and regulations. And then there's a little box 12 that says other. And in the HIMP rules and regulations, it says you can raise any argument that, is potentially viable and not specifically prohibited. So what's a good example I like to use for these? Out-of-network treatment, right? That's not something that is specifically contemplated by the hemp rules and regulations. They don't tell you that you can't object on those grounds, but it's not a specifically granted objection. But you'd better believe that it's one we're going to raise all the time. Or defective form and service. Section 325-6.3c says you have to include proof of ANCR and acceptance. You have to include standardized billing codes, yada, yada, yada. There's a whole paragraph on it. Failure to include that stuff, we've been making an argument that it is defective form and service of the hemp one. Again, not specifically delineated, not specifically prohibited. So we're never, in my opinion, on these hemps, dead in the water, especially since you always have that fee schedule objection at the end of the day.
You know, if anybody else out there is listening and getting excited when Chris is citing statutes, you're not alone, because that excitement is being shared by yours truly. It's such a pleasure to talk about the amount of professionalism that's oozing out of this place with respect to these types of things. And it's absolutely incredible, because if you look at the landscape of New York workers' compensation, Chris, HIMPs are mostly a rising problem because most practitioners, and I'm talking at every stakeholder level, do not know all of the defenses that they possibly have to these things. And the level of service that we can provide, this full buttoned-up service customized to your claim, is exactly what we've been saying since September 15th of 2015, the day we opened our doors here and became the leading defense firm in New York, New Jersey, and now Connecticut. It's incredible that this kind of thing results in indignation of a particular insurance company that decides to skirt rules and try to make arguments that don't make sense, that now have become commonplace to your area of practice.
And, I think that sense of indignation is born out of a sense of duty, right? I don't get offended, but for the fact that I'm getting offended on behalf of our clients. So, right, I don't go home in my personal life and stare awake at the ceiling going, I can't believe these guys are doing this. But you'd better believe when my client is ponying out money on the back end, I'm going, this is illegitimate. This is nonsensical. I want to beat logic into these people. So, I mean, it's really, it does speak to that level of professionalism and tailored service that we're going for here. And I'm glad you brought it up.
Well, if you look at it, right, like here we are in this world where the new PAR and onboard system creates the opportunity for more treatment being authorized to affect hemp exposure down the road. So if we can button this up for all our listeners today, we're talking about a case where treatment may or may not be authorized in the workers' compensation claim. Irrespective of that, the claimant goes and gets the treatment and submits it to a private health insurer. That health insurer then finds out that it should be payable in their eyes through the workers' compensation claim. So their avenue is a reimbursement program, right, after they find a match. And it's not something that your garden variety claimant's attorney is going to litigate before a law judge, right? So most practitioners in the industry aren't really expecting that until, bam, it hits you in the face because you have that $100,000 surgery you brought up later. So it is important. It is a nightmare when those cases come up, right? We should almost have those alerts up when, for example, wait, you got the surgery and you didn't bill me? Then we know that hemp request is coming in, and that's going to come in hot regardless of whether we have a settlement agreement in place, right?
And that's something I think we discussed the last time we went over HIMPs more in detail was, when can you see these freight trains coming down the road? And, the warning signs are all there, right? You've denied a case, but there's a bunch of emergency treatment out the door. Or, you've denied a whole bunch of MG2s, or you filed a whole bunch of C8.1s, right? The warning signs are all there that, every step you're taking, there is potential hemp exposure down the road. But, the next level service your attorneys can provide is when you're getting in voluminous amounts of medical records via subpoena and you're painstakingly going over every single page of those and you go, wait a minute, this case is established to the right knee. Why is this guy getting the left knee arthroscopy on such and such date, right? And it's just this weird little thing that pops up somewhere in the medicals that you're filing it away in case there's a consequential claim later on. But the next level New York workers' comp attorney is looking at going, damn, these guys are going to file a request for a match with the board. All they need is just like some nexus of information, right? Like an approximate data loss to the data service and, matching SSN and matching date of birth. These guys are going to get a match on an unaccepted left knee arthroscopy that, we didn't know about until we got these medical records. And so the next level service you can really offer, knowing about these things, is seeing it coming from that perspective. When you see that weird little outlier that unless you're really looking, you're not going to pick up on it. And it's in those types of situations we can tell our clients, yeah, you can close this out full and final Section 32. But when they're asking you to accept the left knee as a part of that Section 32, heck no. I ain't doing that. I ain't giving you a free ANCR on a site just because you're asking me to do it as part of settling this case. Because I know there's a left knee surgery out there that I'm about to get slapped across the face with a HIMP for, even if they never submitted the bill to the board.
Yeah, talk about next level service. That service resides right here, right? So, Chris Major is really the go-to for this type of stuff. I didn't mention it yet, but he does have a risk transfer handbook that was released this year for the very first time. We talk about the inroads that we're making. This particular win that I'm speaking of, again, I please wish that you have looked at this webinar, this special webinar that we have posted earlier this week. If you haven't, please reach out to Chris so he can show you how great he is, because of the type of next level service that you're really going to get within these four walls. Anything else from you, Chris, before we go on to the next segment?
Just that since you mentioned the risk transfer handbook, for anyone who's curious and keeping score at home, yes, there is a chapter on HIMPs in that, as it is a form of workers' comp subrogation, technically. So, if you're looking at a little bit to brush up on HIMP defense, that is in fact in the handbook. Feel free to reach out to me. I'll send you a copy.
All right. So thanks, Chris, for coming on to the show. We'll be right back with the Paralegal Minute. Hi, everybody, and welcome back to the Third Fridays podcast. We're back for the Paralegal Minute. I hope you like the theme music that lovely and talented John Grayson has put on for this segment. I think it's super cool. I have two new guests this month, Markeitha Joseph and Nicole Yakimic. Welcome to the show, guys.
Hi. Welcome. Thank you for having us.
So happy that you guys are here. We'll get that out of the way, right? Thank you for having us. Laugh, 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 right? So we have this really interesting case that doesn't necessarily have to do with what happened in the courts, but really about what happened because of a situation that really none of us could predict. So Markeitha, it's your case. Nicole and I, we've just heard about it, and it's become almost like folklore. So can you set the stage for what actually happened in your case?
From my belief, the claimant, he assumed that his wife was cheating on him.
All right, so let's just stop there, right? The claimant assumed that his wife is cheating on him. We have listeners right now that are already now in. They're in, right? The claimant assumed his wife is cheating on him. Yeah. So, okay.
He went to the apartment, his sister-in-law's apartment, to confront his wife. And when he got there, he found the superintendent and the sister-in-law, and the wife was not there at all. So he stabbed the sister-in-law. I believe he stabbed her. I don't think he shot her. Yeah.
So he didn't find any evidence of cheating, of adultery.
No.
And he goes and stabs
the sister-in-law. Yes.
Right.
Yes.
Okay.
And then
very calmly stated by you, by the way. So props that. Okay.
And then after that, the superintendent and him begin to get in a tussle with each other. And they're wrestling on the floor. That's where it picks up on the body cam footage when you watch it.
Right, so the police have been called.
The police have been called. And then when the police get to the apartment, the claimant and the superintendent are wrestling on the floor for either the weapon or they're just trying, like, the claimant's trying to stab him or hurt him, and they're fighting. And then the cops shoot him. They didn't really, like, be like, hey, get off of him. They just shot him.
Boom.
Yeah. Yeah.
Like, meanwhile, I guess the listeners should really know, none of this incident is the work accident.
Yeah, right.
It's a totally different thing that just in the course of having an open claim, this claimant just decides, you know what, my wife's cheating on me. I'm going to go commit some violence.
Which also, like, confuzzles me because, like, you state that, like, you have this injury and this injury and this injury, but you were completely okay. You were completely fine to be like, today's the day I'm gonna murder somebody. Like, I don't care if my elbow hurts anymore. Like, today is the day I'm gonna go murder somebody.
Is the person he stabbed okay? Or you don't know that because that's out of, like,
I actually do not know that.
the scope of what you guys are
I'm
handling.
not too sure. I don't think the sister-in-law made it though.
Oh no. Well,
no.
You know, he's got his own problems, I guess. Right?
Yeah.
But you raise a good point, right? It's an open claim, and he decides that he's going to do this, right? And we go from a thought of my wife's cheating on me, adultery, and then I go there. I don't see anything happen, but I'm just gonna go. I'm gonna go after it. So, Nicole, like, I know it's not your case. You hear that when you did hear of it. You know, what were the thoughts that you had?
I think I heard of it from another attorney while I was a legal assistant, so even before I was a paralegal, and basically didn't know anything about workers' comp. And I was like, wow, this is really bad. And then they just kept explaining, like, oh, it gets worse. Oh, it keeps just getting worse. And then I was like, wow, this is really bad. I think that was probably, like, one of the worst files, or, like, one of the worst, like, background information that happens related to workers' comp.
Does that make you want to work on that file, or
no?
Just like,
I don't
get away from it.
Yeah, because I also don't want to see the body cam footage. I haven't seen the body cam footage. I
was just inquisitive. I had to. I had to see, like, how this went down.
How many times have you seen the video?
I've seen it about 3 to 4 times.
Okay, so it's like
I do show a lot of people in the front.
Right. And that's how it becomes a thing, right? We figure it out, and the whole purpose of this segment, obviously, that, you know, our loyal listeners are really cluing in on, is that, you know, you have your run-of-the-mill slip and falls, right? You have your, you know, your regular injuries that happen in the course of employment, and then you have these that make you think, what? Yeah. What is going on? So, how do we know who called the police? I guess the sister-in-law was stabbed.
Yeah, she was stabbed.
And then the superintendent is now fighting with the guy.
Yeah, so it probably had to be a neighbor. Yeah,
neighbor?
I do believe it was an apartment complex in New York.
There's there's a New York Times article on it, I'm pretty sure. Yeah.
Are you okay to read that?
Right.
Because you don't want to watch the video.
It doesn't show the body cam footage of the person potentially being, like, shot by the police. Well, I actually don't know how much the body cam footage shows.
Right. So Nicole will read it in print.
Yeah.
Right.
Maybe not like a digital New York Times article, though, that might have a link to the video.
Right. Well, I don't know if that's public knowledge. Body cam footage?
I guess it could be, right? But maybe not, depending on how. It's not a high profile case.
No, not at all.
Like, we have it just from the course of what we do, right?
No, the thing, it's public.
Oh, it is public?
Really? Yeah, if you Google the claimant's name, it does pop up on the internet.
Wow.
Yeah.
Oh, okay.
Is that how essentially we found it?
I'm not too
Can't be like
sure.
We're not just Googling the claimant's name like left and right.
I'm not too sure because
or maybe we are.
Like I said, like I picked up the case. Like my attorney and I picked up the case after the whole incident, and we picked it up to the point where we were about to close it in the stipulation part. We had like one deposition left, and I Googled it on my own. I was just like, after I heard the facts of the case from another paralegal who handled it before, I was like, I gotta see or like read about.
Oh, so
this.
you heard about like what had happened, right? So the depositions were on something other than whatever
Mhm.
happened, right? And
Mhm.
then you Google it and you figure out, oh, this is now public,
Yeah.
that this thing happened. And I don't even know. I mean, like, what if he didn't die? What do we do then?
What do you do about your claim in general? Because like that's like I said before, like that's a good reason for us to be like, okay, like how did you go injured and decide to like do this active thing? It's not like it's like a sedentary thing. Like
Right.
that's effort.
You really put forth some effort
Yeah.
to do something
Mhm.
so heinous that now the video of you doing so is now available for everyone to see.
Yeah.
Right.
Mhm.
Is it typical when a claimant passes away that the attorney will typically like let the adversary know that this person has passed? Because doesn't it change like?
I guess in theory, the risk is that if they didn't,
Yeah.
right?
Mhm.
And then our client keeps paying checks,
Mhm.
what if they're cashed by the beneficiaries,
Yeah.
right? Like,
Mhm.
oh, like this is my brother, my father, I'm going to cash these checks.
Yeah.
Whereas in this particular case, the depositions you guys were doing were on like a posthumous schedule loss of use, right?
Yeah.
Event,
Right.
because
I know like MMI and stuff like that. Yeah.
so the award is going to go to beneficiaries of the estate,
Right.
right? So like if the attorney doesn't tell us about it, then and those checks keep getting cashed, you might have an issue there, right?
Mhm.
Okay.
So it's better off, right, to say something that right, so that you're not risking something in the future as a claimant's attorney.
Right.
Yeah.
Okay.
Well, what do I know? I don't know. I've never been a claimant's attorney. Never want to be one.
Just asking hypothetically. 'Cause I know it happens other times with like other cases and people pass away.
Yeah.
And,
Yeah.
Yeah.
Like before I had a case where
Well, sometimes the claimant's attorney doesn't know, right? Like,
oh, really?
Like, hey,
Oh.
I've been calling. I don't know.
Yeah.
And then, the employer, right, that we represent may have a coworker that knows things like, oh, can you check up on so-and-so? Like,
Mhm.
And they find out, oh, he's dead.
Yeah.
Yeah. But before I was saying that like I had a case where like he died on the job, so like that's like
Right.
completely
so then you
different
might have a
than-
work-related death versus
Yeah.
just death by adulterous
Right.
murder.
Mm-hmm.
Right. Right.
Mm-hmm.
So, okay. And what I was saying before, right? It's like, what if he didn't die,
Yeah.
right? Then he's alive with like this intervening event that everybody knows about. And it might actually be harder for him to collect benefits because everyone's just like, well.
How does
Right.
that work if a claimant goes to prison?
Oh yeah, that was my other question that I asked the other handling attorney on this file.
Yeah. So there's a statute
Mhm.
that says that if you are in prison for a felony, then you cannot collect workers' compensation.
Oh, okay.
Kind of makes sense because
Right, yeah.
the idea is you're collecting benefits because you can't work, right? But if you're in prison,
You're like
Mhm.
that's the reason why you can't
Yeah.
work.
Yeah.
Because you're in prison, right?
Mhm.
So a lot of times, when that happens, the claimant's attorney will be forthright. The first episode of the Paralegal Minute
Mhm.
months ago with Morgan and Emily,
Mhm.
their case was about a guy who was a drug mule.
Oh.
Whoa.
Wow.
So clearly from the reactions you guys listened. Thanks a lot,
Yeah, it was
guys.
a great podcast.
Yeah, thanks for supporting me.
Yeah.
I always knew you guys were my friends.
You're welcome.
So their case was a drug mule where we didn't even find out until the claimant's attorney told us, like, hey, he was arrested. And so what they did was kind of similar to you. They did like the Googling, like, oh, that's what he was arrested for?
Yeah.
He was a drug mule?
Okay.
Ugh. And then we start talking about, it's like, oh, well, is that work? Are you working? Are you making money? You know?
Yeah, it's like Uber Eats.
Right. You're like, nah, it's reduced earnings. Right? So, in this case specifically, it is unfortunate, right? We've been laughing a lot about it just because it's insane.
Yeah.
But we should say, we're not like saying this is unfortunate. We're certainly, aware of the fact that this is truly, truly an unfortunate circumstance.
Yeah.
It is one of those situations that you just don't think it's going to happen
until it happens.
Right?
Mm-hmm.
And in a weird way, like I said, if he had remained alive, then you'd have all these things that you were talking about, Marquita, right? Like he's able to do these activities, which means maybe he shouldn't get any awards. Now he has an intervening event, like if he's shot and he survives, is his reason for working because of our work accident to the elbow? Or because he was shot?
Yeah,
right?
Maybe some nice apportionment.
Oh, right. Like, how do we, and it just creates this weird situation where I think maybe sometimes claimants think that it's like, oh, this is just a thing on the side that I'm getting these checks every week. I can go about my life and think that my wife is cheating on me. And then, I don't know, stab her sister, presumably, right? It's not like she was cheating on him with her sister. Why does a sister-in-law get stabbed?
I think he just took his rage out on whoever was there.
Yeah,
and it just happened to be the sister-in-law.
Heat of the moment.
We're like, but why do that? Like, does he think the superintendent's cheating? Is that the guy that's involved?
I have no idea. I don't know that answer.
Right.
I'll do some more Googling.
Like
New York Times article.
Okay.
It's pretty good, yeah.
Right. I mean, cross my heart. I mean, I don't think, because you never know. I don't think I've been cheated on. But if I ever found out, I'd be like, okay, I'm out.
Right.
Right? Like, like the normal human response.
Yeah.
Right.
Like, I don't know. I just feel like I wouldn't leap to the threshold.
Statistically, the person who's like the highest chance to kill you is your spouse.
That's super deep.
But also, you don't know if there was other factors
of course,
of him killing the other person. Like, it could have they could have just said, oh, it was because of cheating, when it could have been maybe other issues that we don't know about.
Also a good point,
because we're not privy to that.
Who are the living witnesses to tell this story?
Exactly.
Not him. He could be the hero.
Maybe. We don't know what the superintendent was doing, or
just to get a little off topic. So you said that the person most likely to kill you is your spouse, right?
Yes.
So my cousin got married in October, and so his brother, my other cousin, is doing the best man speech, and he does all the stories about all these things that how they're great together and things like that, right? And he's like, I just want to raise a glass and have the bride and groom look into each other's eyes. And he goes, you are now looking at the person that is statistically most likely to kill you.
Yeah.
So be nice. And I was like, I brought the house down. Everyone was laughing. It was insane. And that has nothing to do with this podcast, but I just wanted to riff on whatever you just said. Being most likely to do it.
Because it's true.
I hope we still remember this claim. This is like an all-time fact pattern.
We have to.
Right. And it's close to settling, right?
Yeah, we're just waiting on survivorship, which is also really funny because his wife is taking the money.
Oh, the person who's
the
person who is allegedly cheating on him is now benefiting from this.
Yeah,
that
opens up a whole new can of worms that I don't even know if we have time for. What were you gonna say?
I was like, it's almost like justice,
justice. But what if the claimant was the hero? You said I don't know what the superintendent was up to.
Yeah, that's true. I was also more looking at the intent of murder and
Sure.
I don't know.
Sure. I took my eyes off the ball there. Right. He did have a murderous intent.
Yes, he did to murder.
Okay.
Yeah.
Right. Well,
my thing is also, what if he succeeded and he did harm his wife?
Right.
Where
let's just say he didn't. He just stabbed the person.
Right.
That also could be a felony to put him in prison.
Yeah.
Right.
That's what I'm saying. Him passing away helped his beneficiaries in that process.
Yeah, that is true. Yeah.
Huh.
Interesting.
Well, I think we've talked enough about body cam footage, adultery, and public body cam footage, by
Yes,
the way.
it is.
We know that Nicole will never see it. But even though these things do happen, right, I think it makes more of a play for what we do in our regular lives, right?
Mm-hmm.
I think one of the key things that you mentioned, Marquita, today is not so much the juiciness of this fact pattern, but like when we hear about it, we're going to do those investigation tactics for claims to make sure that we know everything we can possibly do. And I think that's one of the pillars of professionalism and service. So what was all lost in body cam footage, adultery, stabbing, murdering by someone else, right? How do we get to a point of making sure that everything gets the right amount of attention? So I think that was a great way to tie it up. I actually am proud of myself for the way that I did that.
Yes.
What do you guys think?
It was so
Very
good.
nice.
Right.
Yeah.
And since you guys didn't listen to Morgan and Emily's podcast, do you guys think you'll listen to this one?
Yes, I will.
No, there was a pause. There was a pause. It's okay. It's okay. We're cool. We're cool no matter what. Thank you guys for coming on the show. Marquita Joseph, Nicole Yakimic, and for Christopher Major from segment 1, this is Christian Cison reminding you to defend from day one.